series, my lord. X signature, my lord, of the thumb impression of the X and Y.
Where? In the cell deed?
Yes, ma'am. Cell deed. So for the procedure regarding the taking the thumb impression is concerned, my lord, not the thumb impression of the plaintiff was not taken in the court, my lord, by the sub-inspector, my lord. That was the never challenged, my lord, by the defendants, my lord, and never objected. While the thumb impressions of the plaintiff was collected.
Exhibit X and Y both were on the cell deed.
One thumb impressions, the X. अलग से फोटो कॉपी करके उसको ये करके रखा गया है, उसको कल करके उसको दो जगह रखा। One marked as X and second one marked as Y.
आप मेरा बात समझ नहीं रहे हैं, आपको पता नहीं। Exhibit X and Y both were on the cell deed. There were three exhibits: A, X, and Y.
Yes.
X and Y was compared with A.
Yeah.
Correct?
Yes.
X and Y कहाँ है पोजीशन उसका? सेल डीड में है कि परमिशन में है?
सेल डीड में और परमिशन सेल डीड में है। सेल डीड में।
आप देख के बता रहे, बिना देख के बता रहे?
हम रिकॉर्ड हम देखे हैं, वहीं से हम एग्जामिन किए हैं।
बताइए, सेल डीड है यहाँ पर, निकालिए इसमें।
मेरे पास एग्जिबिट नहीं होगी, तो वहीं से हम देखें।
आप देखे हैं ना, निकाल के
देखें।
सेल डीड आपको दिए। देखे होते तो इतना टाइम नहीं लगता, जितना टाइम लगा रहे। 4 पन्ना का सेल
जेरोक्स करके उस पर सर्कल किया हुआ है।
जेरोक्स करके सर्कल नहीं होता। सर्कल एग्जिबिट मार्क करते समय होता है।
किया हुआ है, हम देखना चाहते हैं।
सेल रीड पे देखें, दिखाइए। Specimen was marked X and Y.
X having the
वो specimen signature.
G
Like specimen X and Y. Sale deed वाला A.
cell deed.
दूसरे पॉइंट पे क्या बोलना है? Challenging the sale deed.
Challenging the cell deed. One judgment manner the earlier has the referred manner. That judgments manner the paragraph 23 says manner this is not necessary manner to challenge each and every deed manner. And it was from the evidences of the
Which judgment is that?
judgments manner 2024 HEC online
Yes.
Supreme Court 2456 manner.
Para 23.
23 manner. A faint effort was made in the end to contend that the plaintiff respondent Nandulal had not asked for any relief for cancellation of said deed by which the property was purchased by the defendant appellant SK Ghulam, the Lalchand, and therefore is not entitled to any relief in the suit. The argument has been noted only to be rejected for the simple reason that Section 31 of the Specific Relief Act 1963 uses the word may for getting declare the instrument as void, which is not imperative in every case, the more particularly when the person is not a party to such an instrument. This case, my lord, from the evidences, my lord, and exhibits, it proves, my lord, this plaintiff, my lord, not the party in the instrument, man.
Here the plaintiff is a party to the instrument. It was only on evidence it was proved that it was by impersonation.
And
So,
yes, my lord, this is the case of impersonation, my lord. But therefore, my lord, this subsequently evidence has become, my lord, on record, my lord, this the defendants, my lord, they got the cell deed.
you
By
see, it is
playing
one
the
thing to say,
impersonation.
it is one thing
So-
to say that Mr. A is not a party to the sale deed executed by Mr. B in favor of Mr. C. Then under such circumstances, sale deed need not be declared null and void. There may not be any declaration to that effect. If he is otherwise able to prove that it is his property, right? But in a case where there is an execution of sale deed by A in favor of B, and without seeking any declaration that this particular sale deed is not executed by him, then how, under what circumstances will the relief be barred by law?
Yes, because so far the limitation is concerned, my lord.
We are not on the limitation.
Yes,
There is
ma'am.
no prayer to set it aside.
Yes, ma'am.
Both the
Only-
courts assumed that the sale deed is under challenge.
Even
That is why they have dealt with the
even,
limitation.
yes, madam, even the trial court, madam, it has been assumed, madam, that the plaintiff sought the relief for declaration of right title for cancellation of sale deed. But, madam, even if madam was there is the finding of the trial court, madam, though madam this as per these judgments, madam, not need, my lord, as because, my lord, the settled law, my lord, was when the person is not in party, my lord, instrument there. And this is the word the use is may. Therefore, my lord, it was not necessary to challenge each and every deed, my lord, for the cancelling. so far the judgment, the 2010, the point of the limitation is concerned, the Article 59 is not applicable, the rather Article 56. This is they got the deed, by playing fraud, and it has come in the knowledge of this the plaintiff, in the year 2011. It appears from the as per the pleading of the para
The
17.
question of limitation would have come only when
Yes, my lord.
there was a challenge to the sale deed.
Challenge.
There was no challenge to the sale deed.
Yes, my lord, I have not challenged.
So for the purposes of declaration of fraud, right? What is the limitation? Fraud is a nullity. If it is found to be fraud, it is a nullity.
Yes, my lord, from the date of knowledge, as per Article 36, the 56, my lord.
Limitation Act. To declare the forgery of an instrument issued or registered.
From
Right?
the date of knowledge.
So therefore, if an instrument is to be declared to be obtained by forgery, then 3 years limitation is there.
3 years.
And here is a case where he says that this is an instrument obtained by forgery because he is not a signatory to the instrument.
But the defendants, they relying on the Article 59 of the Limitation Act, Therefore, my argument.
Therefore, the second appeal, no. His specific case is that this sale deed has not been challenged. In case of forgery also, the sale deed is required to be challenged and the period of limitation has been prescribed to be 3 years. And you want to say that in case of forgery, there is no limitation.
No limitation. 3 years from the date of knowledge,
The deed need not be challenged.
A deed, it may not be challenged, but this is the judgment of the Supreme Court, I am relying on 2024,
In terms of section 56 also you have not pleaded, you have not made sought any relief. You are not seeking a declaration that the deed has been obtained by forgery. There is no such declaration.
There is no such declaration.
There is no such prayer for declaration.
Therefore, my arguments, did not required, when the person is not party in the instrument, therefore, my argument,
So you have not sought, you are referring to section 56 that it will
56 as because, the defendants, they are referring on the point of the limitation of the articles, the 59, Therefore, I am referring the articles, the 56 as because, the 59 is not, when in the case of the forgery, the article 59, 56 is applicable, but not 59. Therefore, arguing the point.
When you have not executed any sale deed, when
no
a person, just a
limitation,
moment,
yes,
when a person has not executed any sale deed,
then no question of limitation. There is no question of limitation.
that's all. Okay. बोलना है आपको
केवल एक चीज़ ऐड कर दे रहे हैं मैडम इसमें कि ये एक जो सेक्शन 31 का जो बात हम बोले वो इसलिए इम्पोर्टेंट था क्योंकि जो टाइटल पे जो डिस्प्यूट हो गया, क्लाउड हो गया, इट कैन ओनली बी रिमूव बाय सीकिंग एनी रिलीफ विथ रिस्पेक्ट टू, ये वर्ड हम शायद नहीं बोल पाए, सीकिंग एनी रिलीफ विथ रिस्पेक्ट टू दैट।
Second
एक
appeal
हम
334 of
एक जजमेंट है
2017.
अगर पैराग्राफ 19 अगर देख लिया उसमें यही बात है, पुराने वाले एक्ट में सेक्शन 39 था जिसमें 3 इंग्रेडिएंट्स को कंसीडर करते हुए 2021 में सुप्रीम कोर्ट ने कहा कि 3 एलिमेंट होना चाहिए, तो अगर उसके रिलीफ के लिए उस रीट के डिक्लेरेशन के लिए पहला की इंस्ट्रूमेंट है वाइड या वाइडेबल अगेंस्ट द वाइडेबल होना चाहिए, द प्लेंटिफ may reasonably apprehend serious injury by the instrument being left, and third, in the case circumstances of the case the court considers is proper to grant this relief। और इसी के पैरा 15 में ये एक्सप्लेन किया गया ऑनरेबल सुप्रीम कोर्ट के द्वारा कि अगर कोई इंस्ट्रूमेंट में कोई कॉन्ट्रैक्ट में पार्टी अगर उसमें नहीं है तब उनको डिक्लेरेशन ऑफ टाइटल मांगना होगा, लेकिन अगर वो कोई इंस्ट्रूमेंट में वो पार्टी है या परपोर्टेड टू भी है तो उसके लिए उनको कैंसिलेशन मांगना ही पड़ेगा क्योंकि वहाँ डाउट आ जाएगा कि वो टाइटल उससे आया कि नहीं। ये
Para 15?
19 है, एक 2021 का 4 SCC पैरा 19।
चार SCC पेज नंबर
से स्टार्ट हो रहा है 786 से, लेकिन जो रेलेवेंट है
786
जी
पैराग्राफ
19 है, पेज नंबर 810।
90 नहीं देखिए सेकेंड अपील नंबर 334 of 2017 for the learned counsel appearing on behalf of the parties. The this appeal arises out of judgment and decree dated 2/6/2017 passed by learned district judge Sindega, whereby title appeal number 7 of 2016 has been dismissed and the judgment and decree dated 30/6/2016 passed by learned sub-judge 1 within bracket civil judge senior division -1 bracket 2 Sindega in title suit number 9 of 2012 has been confirmed. There are concurrent findings recorded by both the courts, and the defendant number 1 of the suit is the plaintiff, is the appellant before this court. The defendant number 2 was the deputy commissioner who did not participate in the proceedings, and the suit was decreed ex parte with respect to defendant number 2. अपील में भी नहीं अपीयर हुए थे defendant number 2. The defendant number 2 did not appear before the appellate court also, and before this court also the defendant number 2, who is respondent number 2 in the present case, is not appearing. The appeal was admitted on 31/8/2018 on the following substantial question of law. Quote करिए, whether element of fraud are required to be pleaded and proved by cogent evidence, comma, the findings of learned court below otherwise in this regard are wholly perverse and against the mandate of law. Further substantial question of law has been framed by the order dated 6th of January 2025, which is as follows. Quote, whether the sale deed executed through impersonation of the vendor was at all required to be specifically challenged in order to hold the same as nullity/void ab initio. The learned counsel appearing on behalf of the appellant has submitted that in the plaint there was an allegation of impersonation of the plaintiff while seeking permission from the Deputy Commissioner under Section 46 of the Jharkhand Tenancy Act for sale of the property in favor of defendant number 1, and also an allegation that the sale deed was also executed through impersonation, but the impersonation was not proved through cogent evidence. He has further submitted that that no relief was prayed for seeking declaration of the sale deed as null and void or void ab initio. The learned counsel, by referring to the trial court judgment, has referred to the issues framed in paragraph 4 and has submitted that issue number 1, 2, 3, 4 and 6 were dealt with together in paragraph 10. He has submitted that the specimen thumb impression of the plaintiff was not taken in the court, but was not taken in the court, and the handwriting expert and the signature of the vendor of the sale deed was marked Exhibit A. The handwriting expert deposed that Exhibit A did not match with signature नहीं होगा, thumb impression Exhibit A में, है ना? Did not match with Exhibit X and Y. He has submitted that the handwriting expert's report was marked Exhibit 2. The learned counsel has submitted that the report of handwriting expert is not conclusive proof, and for this he has relied upon the judgment passed by Honorable Supreme Court reported in bracket 1963 bracket AIR 1963 bracket नहीं लेगा, AIR 1963 SC 1728 paragraph 26. The learned counsel has submitted that the approach of the learned courts with respect to reliance on the handwriting expert was misplaced, and they have treated the report of handwriting expert as a conclusive proof. The learned counsel has further submitted that the learned counsel has further submitted that even if the finding with regard to impersonation is taken as correct for a moment, then also no relief could have been granted to the plaintiff, as the plaintiff never challenged the sale deed in the suit. Rather, the plaintiff only sought a declaration of right, title, interest and possession. Although as per the sale deed, the vendor was the plaintiff. The learned counsel has referred to section 31 of the Specific Relief Act and has relied upon the judgment passed by Honorable Supreme Court reported in AIR 2000 SC 211, paragraph 19, to submit that when the plaintiff seeks to establish his title to the property, which cannot be established without avoiding the decree or an instrument that stands as insurmountable obstacle in his way, which otherwise binds him, though not a party, the plaintiff necessarily has to seek a declaration and have that decree, instrument or contract cancelled or set aside or rescinded. And he is bound to lay the suit within 3 years from the date when the fact entitling the plaintiff to have the decree or instrument set aside first became known to him. The learned counsel has submitted that in the present case, the sale deed duly registered created a serious obstruction in the right of the plaintiff, which was otherwise binding on him, and in absence of any relief seeking cancellation of the instrument, no relief could have been granted to the plaintiff. The learned counsel has also relied upon the judgment passed by the Honorable Supreme Court, reported in bracket 2021 bracket close 4 SCC 786 para 19, to submit that the earlier corresponding provision of Specific Relief Act as it stood under कौन सा एक्ट था पुराना वाला 39 है ना इसमें What was that act? What was that act?
It was the Specific Relief Act. Earlier section was different, madam.
Which? What was the act earlier? कौन सा act?
Specific Relief ही Act का वो अदर्स
से year होगा ना?
हाँ ईयर है वो.
बताइए. What was that? नहीं है ना स्पेसिफिक रिलीफ एक्ट 1963 से तो पुराना कोई एक्ट ऐसा रिपील नहीं दिख रहा
1877.
Specific Relief Act 1877. 1877.
Yes.
The corresponding section was section 39 to the present section 31, and I submitted that in paragraph 19, a reference of the earlier judgment reported in 1959 SCC Online Madras 314 has been made, wherein it was clarified that 3 conditions are requisite for exercise of jurisdiction to cancel an instrument. 1. The instrument is void or voidable against plaintiff. 2. Plaintiff may reasonably apprehend serious injury by the instrument being left outstanding. 3. In the circumstances of the case, the court considers it proper to grant this relief of preventive justice. बस हो गया आपका सबमिशन. The learned counsel appearing on behalf of the respondent number 1 the plaintiff, has opposed the prayer and has submitted that the substantial questions of law are to be answered in favor of the plaintiff. He has submitted that he has relied upon the judgment passed by the Honorable Supreme Court reported in 2024 SCC Online SC 2456, paragraph 23, and has submitted that the Honorable Supreme Court has held that the relief under Section 31 of Specific Relief Act 1963 to be granted by the court is accompanied with the word may, and therefore it is the discretion of the court He has submitted that in case of fraud slash impersonation in the present case, the impersonation having been proved, the sale deed is void ab initio, and therefore there was no need and a nullity, and therefore there was no need to seek such a declaration. The learned counsel has submitted that the appellant has referred to section 59. The learned courts has referred to section 59 of the Limitation Act. But section 59 has no role to play, it is section 56. The learned counsel has further submitted that so far as the evidence of handwriting expert is concerned, the other evidences were also placed on record, and at no point of time there was any objection with regard to taking of sample of the sample, that is exhibit X and Y, particularly the manner in which it was taken, and the handwriting expert was also had also appeared and was cross-examined, and therefore it is not a case that the court has only relied upon the evidence of a handwriting expert to give a finding. Rather, the appellants are trying to make out a new case by objecting to the manner in which the handwriting, the sample was taken. The learned counsel has submitted that there are concurrent findings in connection with impersonation, and it has been admitted by the learned counsel for the appellant that there was foundational pleading in the plaint itself regarding impersonation slash fraud, and accordingly the first question of law is required to be answered in favor of the plaintiff. He has submitted that the questions of law be answered in favor of the plaintiff and the appeal be dismissed. That's all.
Yes, ma'am.
Arguments concluded. Judgment है to date दीजिए तो. लाइए जज. आप ऐसा करिए ना इसको judgment on 3rd March. इसका एक जजमेंट का कॉपी दे देंगे, ठीक है? 2021 वॉल्यूम 4, 2 जजमेंट यहाँ पर है और एक तीसरा जजमेंट ये है। आपने तो कोई जजमेंट साइट नहीं किया है?
एक ये वही
हाँ।
2024 का जो
Sorry.
ऑनलाइन
एक ये फाइल किया है प्लेंटिफ ने, ये रिस्पोंडेंट, ये अपीलेंट, specific leave act, limitation act. ये भी इसी का ही पार्ट है।
From daily list, item Q, 2nd April 244 of 2023.
This is judgment of affirmance by the appeal by the defendant number 1. Now the plaintiff, respondent number 1, filed a suit for specific performance of contract. The agreement is dated 27th of April 2016, Exhibit 1. Now I will be permitted to narrate the case note in very short. The Lordship will find from the trial court judgment itself. So for the gist of case of the plaintiff is that the property which has been described in Schedule A to be appended to the plaintiff was acquired by the
Para 4 of the trial court judgment.
Para 2, page 46. Running page 46, inner page 2.
46.
Inner page 2. Para 2.
Inner page 2. Para 2. Okay.
The case of the plaintiffs in brief.
You are the defendant?
I am the defendant number 1. There are 2 sets of defendants. The case of the plaintiffs in
Why
brief.
2 sets of defendants?
Because we are joint purchase. Now one defendant number 2 alleged to have been colluded with the plaintiff and he sided with the plaintiff. Therefore, and defendant number 1 contested. Therefore, I am reading just relevant part only. I am not
Okay.
very much.
Yes.
The Lordship may kindly see the case of the plaintiff in brief is that the land with the structures thereon secured by boundary walls more fully described in Schedule. That we belong to Hindustan Hardcore Company Private Limited, which was put on auction by the recovery officer, Debt Recovery Tribunal, DRT Ranchi, in recovery proceedings. Now, Chandan Chakravarti, the Lordship just see, he is defendant number 2. Chandan Chakravarti, he along with the present appellant before Lordship, Vidyanand Bharti, made a bid of rupees 10,75,000 to purchase the Schedule A property, having deposited initial money of rupees 2,50,000 with recovery officer, agreeing to pay rupees 8,25,000 on acceptance of the bid. The bid of the above named 2 bidders, defendant number 1 and pro forma defendant number 2, who is Chandan Chakra, was accepted by the recovery officer, and following acceptance, such and such to deposit balance bid amount of sale rupees 9 lakhs within 3 months from the date of the acceptance of the bid, that is 15/6/11. But the above named bidders could not arrange funds to deposit the balance bid amount
for consideration money of recovery officer so as to conclude the auction purchase and to get the sale confirmed by the recovery officer. So the above named bidders started looking for potential buyers of Schedule A property who would not only readily agree to buy the said property at a reasonable price but also would pay rupees 8,25,000 advance within a short notice. Then recovery officer DRT as balance consideration of bid money. Then plaintiffs paid rupees 11,000 in cash to Chandan Chakravarti as advance and acknowledge the receipt of the other sum as shown in scheduled payments appended to facilitate the deposition of balance bid amount and consideration amount of recovery of such DRT so as to completely confirm the auction sale. It was alleged between the plaintiffs and the above named bidders that the plaintiffs would pay a part of the agreed sale consideration, that is rupees 8,25,000 by demand draft drawn in favor of DRT and get it confirmed. On 24th, that is a formal agreement for sale was drawn up on 27/4/2006, that is Exhibit 1, wherein the defendant number 1 and the pro forma defendant number 2 were vendors and the plaintiffs were the purchasers, whereby the vendors agreed to sell Schedule A property for Vendi for consideration of 19,50,000 as the dues of the said stipulated consideration paid rupees 3 lakhs by 8 demand draft drawn in favor of DRT. The details of which are furnished to be apportioned to the balance consideration amount certain. The defendant number 1 and pro forma defendant number 2 duly acknowledged receipt of advance consideration and on 27/4/2006 the plaintiff paid a sum of 5,25,000 by several drafts drawn in favor of DRT, detailing the schedule on behalf of the various vendors. Consequently, the plaintiff paid part consideration of rupees 8,50,000, 25,000 out of total stipulated consideration of rupees 19,50,000. Plaintiff also deposited rupees 10,760 with DRT as bondage money for completion of the sale. Auction sale. The vendors of the agreement dated notwithstanding that there was no agreement or understanding between the plaintiffs and their vendors, Chandan Chakravarti and Hidayanand Bhati, for payment of bondage charge. Upon the plaintiffs to complete the confirmed auction sale as well as to obtain the sale certificate in order to expedite the sale confirmation, to ensure expeditious performance of agreement dated 27/4/2006, they have paid rupees 10,000. Further case of the plaintiff is that they have always been and are still ready and willing to perform their part of agreement dated 27/4/2006. Not only they took great pain to pay the balance bid money as well as bondage fees, the obtaining sale certificate from DRT on behalf of the above named vendors, plaintiffs, but immediately after issuance of sale certificate, the plaintiffs paid a further sum of 3 lakhs on 27/6/2006, 3,85,000 on 18/9/2006 by cash to the vendors Chandan Chakravarti and Hidayanand Bharati, who acknowledged the receipt thereof, and for sale dated 27/4/2006, plus out of total stipulated consideration of rupees 19,50,000, the plaintiff paid rupees 15,21,000 to the vendor Chandan Chakravarti, Hidayanand Bharati, up to 18/9/2006, requested the vendors to start transferring the Schedule A. The vendors acceded to the proposal of the plaintiffs and started transferring the portion of Schedule A in favor of persons nominated by the plaintiffs, and 5 such transfer of portion Schedule A were done by the vendors jointly on 18/9/2006 and 6/10/2006. Thus, both the vendors sold and transferred 23 decimal out of total land of Schedule A, that is 87, to the vendors on 27 rise. Defendant balance land was transferred. The defendant number 1 started showing reluctance to transfer and remaining lands, and obviously such reluctance was fueled by his advice of higher consideration. But the co-vendor Chandan Chakravarti had all along been ready and willing to perform part of the agreement. Thus, performance of agreement remained on hold for at least a year, that is from 6/10/2006 to 4/10/2006. Pro forma defendant number 2 offered to transfer his half share, the remainder of Schedule A, that is approximately 38 decimal out of Schedule A, by executing sale deed in favor of the plaintiffs or their nominees. As the plaintiffs were ever ready and willing to whip up the deal So they decided to get Chandan's share Schedule A land to persuade the defendant number 1 to transfer the balance land either jointly with Chandan or separately, and to show their willingness to perform the part of the agreement, paid the balance consideration of this 4,29,000 to Chandan Chakraborty on 4/10/2007. Chandan acknowledged the receipt thereof on behalf of himself as well as on behalf of the defendant number 1. Thus, the plaintiffs paid entire consideration money of rupees 19,50,000 to the above named vendors, and they became entitled to get remaining 76 decimal land of Schedule A transferred in their favor pursuant to agreement dated 27/4/2006 through transfers made either jointly or by both the vendors or separately by each of them to the extent of their respective share. As Chandan Chakraborty was ready to transfer his share, balance 76 decimal of Schedule A, immediately on receipt of balance consideration of rupees 4,29,000 on 4/10/2007, he executed 4 sale deeds. Furthermore, he made the plaintiffs to understand that he had authority derived from his co-vendor to transfer the entire major remaining area of 76 decimal approximately. Consequently, Chandan Chakraborty transferred the remaining land of Schedule A to the plaintiffs and his nominees by executing sale deeds on 4/10/2007 and 4/12/2007. Defendant number 1 was aware of the execution of aforesaid sale deeds by his co-vendor, so impliedly those transfers made by Chandan Chakraborty had tacit consent of defendant number 1. Thus, it would have sufficient if defendant number 1 had executed a deed of declaration accepting the transfers made by Chandan Chakraborty by transfers made by both the vendors. When the plaintiffs approached the defendant number 1 with a request to execute formal deed of declaration ratifying the above mentioned 4 sale deeds, defendant number 1 changed his color, and not only he declined to do so, but he continued to say that the co-vendor Chandan Chakraborty could at best sell to the extent of his share, that is approximately 38 out of Schedule A. He alone had right to transfer the remaining 38 decimal of the Schedule A. The defendant aforesaid defiant and recklessment attitude of the defendant number 1 led to serious dispute between the plaintiffs and defendant number 1, which resulted in institution of criminal case, but where ultimately a panchayati was held on 30th March 2008. At the instance of respective people of the locality, the defendant number 1 executed deed of disclaimer on 1/4/2008 that balance consideration of rupees 4,29,000 had been duly received by Chandan Chakraborty on behalf of both the vendors. Thus, total consideration of rupees 9,50,000 had been duly paid by the plaintiffs in the terms of agreement dated 27/4/2006. Defendant number 1 further accepted that it was the legal obligation to maintain sanctity of sale agreement dated 27/4/2006, but owing to some problems, he could not maintain the same. Lastly, he agreed to execute the sale deed in favor of the plaintiff, nominated Janardhan Prasad to transfer his share 38.5 decimal of it. As a matter of fact, he executed separate agreement for sale 1/4/2008, whereby he agreed to transfer the balance 38.5 decimal of land of Schedule A in favor of the plaintiff's nominee, Janardhan Prasad. In the said agreement for sale, a defendant number 1 specifically agreed that total consideration payable to him, that is 9,75,000, or his share of 38.5 decimal of land had been paid to him as full and final amount of consideration. Thus, on a conjoint reading of the sale agreement dated 1/4/2008 and the deed of disclaimer, it is apparent that the agreement dated 1/4/2008 is a part or execution of supplement to the original sale agreement dated 27/4/2006. In the panchayat, defendant number 1's share of land was agreed to be transferred in favor of plaintiff's nominee Janardhan Prasad, and this agreement was in terms of pursuant to the original agreement for sale dated 27/4/2006, and to avoid technical hurdles, Janardhan Prasad, the de facto vendee of the agreement dated 1/4/2008, has been included as pro forma defendant number 2 in the present suit. Defendant number 1 had agreed to transfer his share of land within 25 days from the date of agreement. The plaintiffs and their nominee Janardhan Prasad tried to contact him, but later on declined to meet them, and finally on 17/4/2008 he refused to execute the sale deed or transfer his share of remaining land of Schedule A, which compelled the plaintiff to file the present suit. Plaintiffs have come to learn the defendant 1 has been making clandestine attempt to transfer the land in question. The plaintiffs are already and still willing to perform their part of agreement, and they have already done everything, and they were or are required to do under agreement dated 27/4/2006, like full payment consideration bearing the court fee for execution and registration fee, above mentioned of sale deeds whereby the entire land of Schedule A has been or purported to have been transferred to the plaintiffs or to their nominees through plaintiffs have got the entire land Schedule A 77 decimal approximately transferred by Chandan Chakraborty after defendant number 1 stopped joining his co-vendor in execution and registration of the deed, incurring huge expenditure in preparation, execution and registration of sale deeds, and they are still ready to bear the cost of preparation and execution and registration of sale deeds, whereby the defendant number 1 is to transfer his share of remaining 38.5% of schedule land, the cause of action. Now the case of the defendant number 1 is para 4. Defendant number 1, who is the appellant?
आप
In-
केस बताइए ना, ऐसे पूरा जजमेंट पढ़ के क्या ही
Then हम पढ़े सिर्फ केस जानकारी तो फिर पॉइंट.
हम पढ़ लिए केस, आप बताइए क्या
Now,
आपका
your
point?
lordship may kindly see what has been pleaded by the plaintiff. The court cannot make out a third case, and as per the plaintiff, the case has to be as per the plaintiff. Your lordship would find the suit was filed for execution of specific performance of contract dated 27/4/2006. Now it has been in course of pleading. Your lordship has also found that the date on which the agreement was executed by the defendant number 1 along with one Chandan Chakraborty, the property was not with them. Number 1. Number 2, your lordship may kindly see
Chandan Chakraborty is also a
one of the
party.
purchaser,
Yes.
co-purchaser with the defendant number 1 in a DRT auction. Now DRT auction part payment were made by them, both of them. Now part were to be paid by both of them in lieu of such auction sale and for confirmation of sale deed. At that stage, now on 27/4/2006, an agreement was executed by the defendant number 1 along with Chandan Chakraborty in favor of the plaintiff, expressing their desire to sell it for a sum
Defendant
of
number 1, what was his name?
Yeah,
Defendant number 1, what was his name?
Vidyanand Bharti. He is the appellant.
There,
He is the appellant before us. And defendant number 2 is the performer defendant who is a nominated person of the plaintiff.
just a moment. And Chandan Chakraborty was defendant number?
He is defendant number. Defendant number 3.
Defendant number 3. So defendant number 1 and 2, they entered into an agreement with the plaintiff.
Yes.
Correct?
No, 1 and 3.
1 and 3.
Chandan Chakraborty.
This is dated 27/4/2016.
Yes.
According to this agreement, they had to clear the dues of the DRT auction and
I'm sorry, no. Defendant number 2 is Chandan Chakraborty, and defendant number 3 is the Janardhan Prasad nominated by the plaintiff.
defendant number 2 is the Chandan
He
Chakraborty.
along with present defendant number 1,
Yes.
both of them participated in an auction held by DRT, paid as part money, and the balance money of rupees 8,25,000 was to be paid by them. And in between, before the sale was confirmed, before the property was transferred to them, now they entered into an agreement. And
Dated
that is
27/4/2016.
Yes. Now it is said by the plaintiff. As per the plaintiff's case, I am not adding anything. As per the plaintiff's case, the sale was not complete on the date of agreement, that is on 27/4/2006.
That's right.
Now on that day, the plaintiff agreed to purchase the property to be acquired in the contingent contract,
Yes.
to be acquired by the defendant number 1 and defendant number 2 by getting confirmation of sale from DRT. And on that day, they agreed to sell at rupees 19,50,000. Total area is 77 decimal. Total area is 77.
This amount, total area is 98.8 decimal.
Yes, so now they agreed.
98.8 decimal.
Yes. Now, out of which, according to the agreement for sale, according to the case of the plaintiff,
Yes.
it was 38.5. belong to Chandan Chakraborty as per his case, and 38.5 belong to the plaintiff, defendant number 1, as per below para 2 of the plaintiff. Para 2 of the
38.5 to defendant number 1,
and defendant number 2, 38.5, according to the plaintiff's
38.5
case,
to defendant number 2.
in absence of any document.
Okay.
Now, it is said that not in course of time, the plaintiff alleged to have paid rupees, the paid and got the sale deed in respect of 38.5 decimal in by Chandan Chakraborty. Now he wants a deed of disclaimer affirming the sale, because he was also one of the defendant number 1 is also one of the partner
Co-owner.
co-owner. So he wants a sale deed which has been to be confirmed by defendant number 1 by executing a deed of disclaimer. This is his case, first case. Second case, he wants that
The
defendant
remaining
number 1
portion
also
should be
should sell
the remaining.
the remaining portion to not to the plaintiff, but to one Janardhan Prasad who is not party to
Who
the
is-
agreement.
Who is the nominee?
He is nominated.
Yes.
Nominated at a subsequent stage. There was no name in the agreement. Now he wants that he should get a defendant number 1 should transfer this 38.5 decimal of land to Janardhan Prasad. And then it is said that in course of time, when the dispute arose, then there was a panchayat and a panchnama was prepared. As per the plaintiff's case, I am not adding anything. Now it is said that part payment has already been made. Still the plaintiff is not in a position, is not avoiding the transfer. Therefore he brought the suit. Now your lordship has to see, the suit was brought for performance of this, the agreement dated 27/4/2006. This is the specific prayer. In absence of any prayer with regard to the specific performance of 1/4/2008, there is no relief sought for. And
What
for
is
that-
1 for 2008?
That is the agreement, further agreement in Panchayat, whereby it is said that defendant number 1 agreed to sell it to Janardhan Prasad pro forma defendant. Your lordship just see the page number. Your lordship just see page number 32, inner page 6 of the trial court judgment, right from 10th line from top. 10th line from top. As a matter of fact, has your lordship got it?
Yes, sir.
As a matter of fact, he means the defendant number 1, executed a separate agreement for sale dated 1/4/2008, whereby he agreed to transfer the balance 38.5 decimal of land of Schedule A in favor of the plaintiff's nominee Janardhan Prasad. What I am submitting to us as per the case. And
Internal
thereafter,
page, sorry, internal page is.
internal page number 6 नीचे लिखा हुआ है 6 out of 16.
Yes.
उसमें जो देखा जाए 10th line from top, as a matter of fact, as your lordship got it, बीच में as a matter of fact, जनार्दन प्रसाद के ठीक नीचे 1 2 3 4 5 6 7 8 9 10 10th line के बाद as a matter of fact शुरू हुआ है।
Defendant number 1. Bottom से ना?
हाँ, नहीं, ऊपर से हुजूर, ऊपर से as a matter of fact 27
हाँ, as a matter of fact.
yes, वहीं से
ठीक.
as a matter of fact he
So
is-
there was no no prayer
Yes,
seeking
now,
enforcement
in
of this
order
agreement.
In order to confirm this, your lordship may kindly see the claim.
Para 1, the suit for specific performance of contract. Can you read this?
Yes,
Has been brought by the plaintiff.
yes, 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 yes. Yes, the suit for a specific performance of contract has been brought by the plaintiffs against the defendants. उसमें 2 आदमी डिफेंडेंट है, एक प्रोफॉर्मा डिफेंडेंट है, for a decree for a specific performance of agreement for sale dated 27/4/2006 in so far as defendant number 1's and transferred share of 38.5 decimal of land of Schedule A is concerned. Next prayer है, directing the defendant number 1 to transfer 38.8 decimal of transferred land, being the residue share of defendant number 1 in Schedule A.
He's
in
seeking
favor of the
enforcement
plaintiff.
of both the agreements. He's seeking enforcement of 27/4/2006
Yes, read
and
with.
then read with
Now,
agreement
the
dated
read with वाला का
1/4/2008.
रिलीफ क्या मांगे हैं? To directing the defendant number 1 to transfer 38.8 decimal of transferred land,
That's right.
being the residue share of defendant number 1 in Schedule A in favor of the plaintiffs or their nominee Janardhan Prasad in terms of agreement dated 27/4/6, read with agreement dated 1/4/2008, or in the case of the court is of the opinion that agreement dated 1/4/2008 is not supplement. This is the resolution. If the court finds that agreement dated 1/4/2008 is not supplement to or part or extension of agreement dated 27/4/2006, rather a separate agreement, then decree for specific performance of agreement dated 1/4/2008. So, putting a question to himself, the plaintiff made an alternative prayer. First prayer with regard to execution of agreement dated 27/4/2006, which is a basic prayer. Now, so far, agreement dated 1/4/2008, plaintiff himself says, if the court finds that it is not a supplementary, then it should be a separate agreement. It is the case of the plaintiff. Now, your lordship may kindly see
कहाँ
what.
फ्रेम किया आपका substantial
जी।
question of law?
अब हुजूर,
Substantial question of law कहाँ फ्रेम?
अब आ रहा हूँ। एक सेकंड इशू दिखा लेते हैं, उसको आते हैं सब्सटेंशियल क्वेश्चन। Your lordship just see not the issues which were framed. Para 6 in our page 9. In our page 9. Is this short maintainable? सब छोड़ देते हैं। 4 में आएगा, 4, 5 और 6 यही important. Whether there is concluded contracts between the parties dated 27/4/2006 with respect to Schedule A, whether the plaintiffs are ready to perform their part of contract in respect of Schedule A, sale dated 27/4/6, whether the plaintiffs are entitled for decree for specific purpose 27/4/6, where is the 1/4/2008? There is no issue at all framed. In absence of any issue, the learned trial court did not answer this aspect of the matter while dealing with issue number 5 and 6. Para 7 onwards, that is page 10 onwards. Para 7, issue number 5 and 6. Issue number 5 and 6 in relation to agreement dated 27/4/2006. Now, your lordship may kindly come to the concluding part. Your lordship would kindly see in our page 12. After hearing learned counsel, as well as on consideration of pleadings and oral and documentary evidence, no oral evidence has been referred to and relied upon in this paragraph. After all, it was done in the subsequent stage. It transpires that defendant number 1 has not disputed the execution of agreement dated 27/4/6. The deed of disclaimer dated 31/3/2008. The agreement for sale dated 1/4/2008. However, that is also against the pleading of the defendant number 1. However, para 17 of his cross-examination in chief has taken a lame excuse. Having regard to his old and ailing father, he had to agree with the condition mentioned in the Panchinama dated 30/3/2008. The deed of disclaimer. Now, it is another question of law. Whether a deed of disclaimer unregistered before a panchayati can be construed to be a disclaimer deed, transferring his own right, disclaiming his own right in absence of any registration of the deed, has been pleaded in his written statement, deed of the, as well as the agreement for sale dated 1/4/2008, but no such case has been pleaded in the written statement. Apparently, it is an afterthought. Again, in para 40, he has stated that the Panchnama and the deed of disclaimer, etc., were got executed by him on the false promise and that the plaintiffs would compromise the criminal case, but there is no such pleading in the written statement, and the law is well settled that the parties cannot travel beyond their pleadings. In para 7 of his cross-examination in chief, he has admitted that the plaintiff had paid rupees 3 lakhs to the defendant, but he has stated that the same was the sale price of bricks lying on the suit premise properties, but there is no such pleading in the written statement. It appears that rupees 3 lakhs was paid by the plaintiff to the defendant on 27/6/2006, the receipt of which was acknowledged by the defendants on the last page of Exhibit 1, sale agreement dated 27/4/6. In para 29, the defendant number 1, PW3, defendant number 1, PW3, BW3, has admitted that after the plaintiff filed the present case in the court, came to know that defendant number 2 had received rupees 4,29,000 from the plaintiff number 1, and he had executed 4 sale deeds. Defendant number 1, defendant number 2, Chandan Chakravarti, 4 sale deeds. The false in view of the deed of disclaimer dated 1/4/2008 executed by him much before the filing of the suit. It shows that he has not come before the court with clean hands. The evidence of PW1 has remained intact in his cross-examination, has fully supported the case. PW2 is also very much consistent. Now, the discussion and ultimate finding, Your Lordship may kindly see here, para page 14.
आपका क्या पॉइंट ऑफ लॉ है बताइए?
From the above, it is
आप
crystal
क्वेश्चन
clear.
ऑफ लॉ में आइए ना सर, देख लिया
सब्सटेंशियल क्वेश्चन पहले
Just
तो
under the substantial.
क्या डिसाइड हुआ वो नहीं दिखाएंगे मुझे
हम देख लिए.
जी
ये क्या है? सेक्शन 10 ऑफ कॉन्ट्रैक्ट एक्ट.
कोई कंटिंजेंट कॉन्ट्रैक्ट जब हमारा हाथ में प्रॉपर्टी ही नहीं था और उस समय एग्रीमेंट हो गया, दैट इज ए कंटिंजेंट.
कंटिंजेंट कॉन्ट्रैक्ट में कोई बार है?
बार है कंटिंजेंट में जब कोई चीज होगा तो हम देंगे,
बैक टू बैक एग्रीमेंट.
इसीलिए सेक्शन 10. और दूसरी बात है जो द एसेंस ऑफ द टाइम, एसेंस ऑफ कॉन्ट्रैक्ट एंड आफ्टर द एक्सपायरी एज स्टिपुलेटेड इन द एग्रीमेंट, द सेल डीड एग्जीक्यूटेड बाय डिफेंडेंट नंबर 2 इन फेवर ऑफ द प्लेंटिफ्स, द शेयर ऑफ द डिफेंडेंट नंबर 1 शुड हैव बीन डिक्लेयर्ड टू बी इनवैलिड. मेरा शेयर को भी बेचे, वो तो ज्वाइंट पार्टीशन हुआ ही नहीं, दैट इज हिज केस. पहले तो एक्विजिशन नहीं हुआ, फिर पार्टीशन नहीं हुआ, अब पार्टीशन नहीं हुआ तो बोलते उनका शेयर उठा के प्रिजम्पशन हो गया. In respect of this presumption, no sheet of paper has been produced that there had been a share between the defendant number 1 and defendant number 2. And small g में हुजूर हम लिखे हैं लास्ट वाला, in absence of my title, I cannot transfer. And it is an admitted fact that on 27/4/2006 there was no title transferred to the defendant number 1 and defendant number 2 by the DRT. Now the appellate court also proceeded ahead without taking into consideration these aspects of the matter.
Specific performance of contract does not say that
There must be title with me, then I can transfer.
specific
Or
performance
propose
of
to
contract.
transfer.
Just a moment. Where does it say that that no agreement can be entered
That
into
is
in
not
anticipation
contracted,
of
no?
that?
Indian contract governs this position. The specific performance of contract, it is a proposal for transfer
That's
of a land which is with me. I am having
there cannot be any
contingent.
any
कि
any
हम इस केस
contingent
में
in the
डिग्री,
sense that a person
हम
is
एग्जाम्पल, इस केस में डिग्री होगा तो हमको क्लाइंट इतना रुपया देगा, और नहीं होगा तो नहीं देगा. लॉटरी है, लॉटरी नहीं
डिग्री
निकलता.
लॉटरी होता है क्या?
नहीं, लॉटरी हो ही नहीं सकता है. इट इज ए कंटिंजेंट.
Is there any legal bar in continuing
Yes,
contract?
that is section 10. You
Like,
also just-
contract act.
I'm very sorry, Lord. And your Lordship may kindly see, it is a settled law. A person cannot sell better than what he has.
The agreement itself said that once payment is made, then this property will be sold to
Yes.
me. And pursuant to that, the plaintiff parted with the money,
Parted with the money.
cleared the dues.
Therefore, there must be confirmation of sale on the record.
Sale has been confirmed, it is not in dispute.
It is not not on record.
The sale has been confirmed, it is not in dispute.
Unless
The dues was paid, the
unless
bondage
the
fee
court
was also
finds it,
paid.
Lord, court has to see. It is the case of the parties.
You see,
May I-
if there is no dispute on that, what the court has to
If I
see?
admit anything beyond the law or
Not
illegal,
beyond the law, it is not beyond the
then,
law.
then also that admission will not bar me. Your Lordship may kindly see, it is the duty
It is
of the
not
court.
beyond the law.
No, it is the duty of the
Any
court.
admitted fact need not be proved, Mr.
Yes,
Sani.
section
You just
52
tell
of the
us.
Indian Evidence
Yes,
Act.
we'll see that.
But where is my admission? I have not admitted the payment. How the court presume that I have admitted everything?
Court is not presuming, the
Court has
pleadings are.
presumed it. If
The
Your Lordship may kindly
pleadings,
see,
you see, the agreement by itself is an admitted document,
agreement,
right?
agreement is an admitted document.
Agreement is
That
not
on
in dispute.
27/4/2006.
Yes.
And there was no,
And it also says that upon payment of this money, the
I agree to
property
sell.
will be
both the,
sold
both
to
the
the
defendants,
plaintiff.
defendant
Yes,
number
so-
1 and defendant number 2,
so agreement is not in
agreed
doubt.
to sell.
Yes, and
No.
and there is also a concurrent findings that the entire consideration amount was paid.
Now, Your Lordship may kindly, that concurrent findings must be based upon certain documents
It is
or
based on
evidence.
certain documents.
Where is those documents? In absence of my, therefore, Lord, my case which has been pleaded by me and supported by me by leading evidence, that
क्या
has not been
लिखा है?
considered. How the court below.
How this section 10 आप दिखाइए contract act section 10 is coming into picture.
Contract. In written statement, I have categorical state that has not been, and the oral
आप section
evidence
10 पे पहले
supported by, I'm just come. I'm very sorry, not subject to correction. Lord. All agreements are contracts. If they are made by free consent of parties competent to contract, for a lawful consideration with a lawful object and are not hereby expressly declared to be void.
So-
Nothing herein contained shall affect the law in force in India. Now, if I am competent to contract for sale of a land, which I did not have,
Okay.
so I did not have on that day, the date of agreement I did not have this land with me. It is an admitted case of the plaintiff.
That is not the question.
On 20, yes ma'am,
I
27,
don't agree
then
to
your
this.
Lordship may kindly come to 24, section 24. If any part of a single consideration for one or more objects or any one of any part of any one of several considerations for a single contract is unlawful, the agreement is void.
There is no unlawful, there is nothing unlawful about
Yes,
it.
section 24 says. If your
The,
Lordship may-
the bidder does not have money, he borrows, he asks somebody to give money and agrees that
But
once
you know,
I get
there are two
the
contracts
property, I will sell it to him.
There are two contracts. The
Yes.
several contracts, section 24 speaks like so, that if any part of a single consideration for one or more objects, there are more objects in the contract, or any part of any one of several consideration for a single object is unlawful. Similar, there are two objects in the contract dated 27/4/2006. Number one, they will pay the amount of the DRT to the DRT, then to get the sale deed confirmed, and thereafter, Lord, I propose to sell. So there are two objects. I have taken this point also in my substantial question of law, section 24. And thirdly, your Lordship will kindly see, it is a specific performance of 27/4/2006 only. No issue was framed with regard to 1/4/2008. It is a case of the plaintiff, but no issue has been framed. And in absence of issue, the court has no occasion to decide it. So it has not been decided whether 1/4/2008 was a valid document, valid agreement, enforceable document, and for which I can be asked to execute the sale deeds in terms of agreement dated 1/4/2008. There is no finding at all. So my humble submission for Lordship would be that issues which were framed, it does not speak or whisper a single word with regard to the subsequent agreement dated 1/4/2008. Nothing has been said. No issue has been framed. So in absence of issue, the appellate court is duty bound.
लिखिए जरा. Second appeal number 244 of 2023. Heard the learned counsel appearing on behalf of the appellant. The learned counsel for the appellant has submitted that the suit was filed seeking specific performance of agreement of sale dated 27/4/2006, read with agreement dated 1/4/2008, with an alternative plea, with an alternative relief that if the agreement dated 1/4/2008 is taken to be a separate agreement, then a decree for specific performance of agreement dated 1/4/2008 be passed.
There was time limit fixed in the agreement, 2 months.
इसको जरा इसका रिलीफ कोट कर देंगे. पेज नंबर 62 में डिक्री में रिलीफ लिखा हुआ है.
डिग्री में भी है.
ये 27/4/2008 क्या है?
27/4/2006.
27 एक 27/4/2008
एक 4/2000
गलती से
वही डेट मिल रहा है. और डिग्री में वो जो ट्रायल कोर्ट का जो डिग्री है लास्ट में जजमेंट के नीचे उसमें वो जो लिखा हुआ है claim has been quoted from the plaintiff.
The learned counsel has submitted that the issues as framed by the learned court had no reference to the agreement dated 1/4/2008. Although the specific performance was prayed in terms of agreement dated 27/4/2006, read with agreement dated 1/4/2008. Correct?
Yes.
He has submitted that in absence of any issue framed with regard to agreement dated 1/4/2008, the suit could not have been decreed. He has also submitted that इतना ही काफी होगा. इसी पे इशू फ्रेम. Considering the submissions, this appeal is admitted for hearing on following substantial question of law. Whether the learned courts would have decreed the suit without framing any issue in connection with the agreement dated 1/4/2008. Issue notice to the respondent number.
All three responses. We are siding with the plaintiff, therefore all three.
Respondent number 1 to 4.
Yes, 1 to 4.
under ordinary process and registered cover for which with 80 for which requisites be filed by Monday. Let the records be called for from the concerned court. It will be open to the parties to pray for framing of additional substantial question of law once the records are received from the concerned court. Post this case on 7th April.
7
April.
I went cancelled this kitab book from this.
Order Saturn 3, 2nd April 48 of 2023.
Yes?
This is an IFA contribution of delay intention.
How much is the delay?
88.
Sorry?
88 days in worship.
SC number 48 of 2023 with IA number 10893 of 2024. Seeking condonation of delay. Issue notice to the sole respondent in the limitation matter you will issue notice in the main appeal also.
It has not been admitted yet.
That's right. In the limitation matter for which requisites be filed by Monday under registered cover with AD as well as ordinary process. Post on 7th of April 25. Let the records be called for from the concerned.
Item 4, 1st April 9 of 2024.
IA for
Substitution of respondent number 2.
substitution
Mine.
of respondent number
2. He died on 30th of October 2024. I filed the petition within time, and legal heirs are 5.
are already on record. Where are the name of the legal heirs?
Yes, that is in the appeal matter. Jawaharlal Sonata. This is serial number 2. Respondent.
IA number 11614 of 2024 in FA number 9 of 2024. The learned counsel for the appellant has submitted that this petition has been filed for substitution of respondent number 2, Jawaharlal Soankar, son of Motilal Soankar, who died on 30/8/2024. He has also submitted that the petition seeking substitution has been filed within time and the details of legal heirs and legal representatives has been mentioned in paragraph 5. Issue notice to the proposed legal heirs and successors of respondent number 2, whose details have been mentioned in paragraph 5 of the interlocutory application, both under registered cover as well as ordinary process. Registered cover with AD. The requisites be filed by Monday.
Within 10 days.
By Monday. Post on 7th April 25. Awaiting service.
Well, one another IA is for stay of.
अभी सबीना substitution के stay कर सकते.
Item 5, 1st April 25 of 2024.
Okay.
Yes. Who is there? Are you there in this case?
Earlier notices were issued to respondent.
Notices were issued.
Yes, ma'am. 99
एक ही रिस्पॉन्डेंट को हुआ था FA नंबर 25 of 2024.
Next is
Counsel for the appellant is present. He submits that as per office note, the sole respondent has refused to accept notice. He submits that the notice be accepted as validly served. Considering the submissions, the notice upon sole respondent is accepted as validly served. क्या सूट था आपका?
Specific performance of contract.
You were plaintiff or dependent?
Plaintiff.
Record आगे.
again.
Why was it declined?
Yes.
Why was it declined?
On merit lot से Mr. Vibhas Sinha will-
Sorry,
On merit lot है Mr. Vibhas Sinha will argue.
the records have already been received from the concerned court. Post this case for final disposal on Tuesday in the supplementary cause list. Tuesday को बहस करी तो वो आ नहीं रहे और यहाँ orders.
Item 6, first appeal 131 of 2024.
Orders का क्या है इसमें? Insufficient address, yes.
They have appeared for respondent, contesting respondent,
Respond number
1 to 5.
1 to 5. What about others?
6 to 15.
6, 7 and 8. 13 to 15 not found at the given address. 9, 13 to 15. Where is the appellant? Where is the appellant?
Mr. Probably Mr. Amar Kumar Sinha.
देखिए फर्स्ट अपील नंबर 131 of 2024. Appellant absent. The learned counsel for respondent number 1 to 5 is present. As per the office note, respondent number 6 has been personally served. Respondent number 7 and 8 has been served through respondent number 6. Who are the who are minors and are being represented through respondent number 6. Respondent number 9, 13 to 15 were not found at the given address. And respondent number 11 and 12 has been served. And as per office note, respondent number 11 and 12 has been served through sister-in-law. Notice upon respondent number 6, 7 and 8 is accepted as valid. Counsel for the appellant is directed to take fresh steps for service of notice upon respondent number 9, 13 to 9, 11 to 15. Sister-in-law को हम लोग नहीं accept करें. Can't be like this. Sister in law, कौन sister in law? Very difficult. What is the relationship? Whether she is staying with them or
Otherwise, we were the only original plaintiffs who have all appeared. They are other.
they never appeared. They never
They are
contested.
the other persons who were impleaded as defendants, and
They never contested.
because only few of the defendants have filed this appeal, therefore they have impleaded other defendants as respondent in this. But since notices have already been directed to be issued, therefore all these steps
Okay.
are necessary.
Fresh steps upon respond number 9, 13 to 15 at their present and correct address, or to take appropriate steps for substituted service of notice. Requisites for fresh service of notice upon respond number 11 and 12 be also filed under registered cover as well as ordinary process within a period of 10 days from today. Post this case on 7th April.
I've mentioned one second appeal of the year in which out of 100 respondents, I am only few respondents I am representing. Matter is of the year 2017, we are in 2024, and because there was a delay of approximately 40-50 days in filing the appeal, notices were issued in that case, and that matter is still at the stage of issuance of notice. So I have mentioned that matter, Your Lordship, I'll request if Your Lordship would.
If in case
No.
case of delay, if there is no substantial question of law involved, by notice be issued in limitation
the
also.
another bench had already passed an order. I have annexed that order where it had noted that first we'll see whether any merit whatsoever is there or not. Therefore, I'll hear it on under order 41 rule 11 and then only further
There is
order.
no point, I don't think
So-
so. That as a matter of course,
And that order has
आपको
already
कुछ
been.
लोगों का आया है,
जी
2 सिस्टर इन लॉ को सर्व हुआ है, तो उसको आपको फ्रेश स्टेप लेना
प्रेस 2 weeks लोड से
हम दे दें 10 days देख लीजिएगा order।
आई विल असेस
आप नो ऑफिस नोट देख लीजिए
हाँ देख लिया हम ऑफिस नोट कर लेंगे उसमें थोड़ा सा आपको
6,
एड्रेस
7 and 8 यहाँ ऑप्शन दिए हैं, यू कैन फाइल इंटरलोकेटरी एप्लीकेशन ऑल्सो फॉर सब्स्टिट्यूटेड सर्विस ऑफ नोटिस जिसका एड्रेस नहीं उपलब्ध है, और जिनका
इसीलिए-
एड्रेस उपलब्ध है उनके लिए फ्रेश
आई एम प्रेइंग फॉर ओनली 2 weeks लोड आई विल ascertain the address of the respondents
हम तो 7th अप्रैल को रखे हैं।
नहीं एक थी रिक्विजिट्स फाइल करने के लिए 2 weeks लोड से प्रेयर कर रहे हैं
अच्छा 10 डेज की जगह 2 वीक्स कर दीजिए, जिसमें दो के अगेंस्ट 2 के खिलाफ तो आपको फिर से फ्रेश रिक्विजिट्स
जी